All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We're here this morning for oral argument in our cause number CV230562, Hintzen Gaines v. Adelson et al. As you can see, we've had a bit of a change of plans this morning. Judge Payton is feeling under the weather. She's not physically here with us, but she did participate in conference this morning and is watching the oral argument live via YouTube, and will let us know if she has any questions. Each side has 20 minutes to present argument. Appellant counsel, you're responsible for reserving your own time for rebuttal. Please keep in mind that we've read the briefs and conferenced the case this morning, and with that, you may proceed.
Thanks, Your Honor. And by the way, the reason I have my cell phone with me, which I usually don't bring, is because Judge Payton may text questions for me to ask. So if you see me pick it up and look at it, it's because Judge Payton has wanted to weigh in.
Well, good morning, Your Honor, and may it please the Court. The case before the Court today must be remanded for two overarching reasons. First, the trial court used the wrong legal standards in evaluating Ms. Hintzen Gaines' claims and appellee's motion to dismiss. And second, the trial court failed to accept the allegations in Ms. Hintzen Gaines' complaint as true and reasonably resolve all inferences in her favor. First, the trial court held on page 6 of its order that claims for false light invasion of privacy are analyzed under an objective reasonable person standard, and that was error. Paragraph 29 on page 580 of the Desert Palm case, cited by the trial court on this point, in fact instructs the standard is whether Ms. Adelson's email would be highly offensive to a reasonable person in the plaintiff's position, and specifies that it is quoting from Restatement Section 652E.
How is a reasonable person standard a subjective standard?
Well, the reasonable person is modified by in the plaintiff's position.
Right, but it can be an objective standard that takes into account the situation of the reasonable person and still be an objective standard.
Well, I would agree with that, especially when it comes to defamation as well. But when we're talking about the interest protected by a false light invasion of privacy claim, it necessarily must be subjective because we're talking about the person's feelings that's been injured. So, sure, if you can put the person in the plaintiff's position into an objective place, well, then you're stepping into the shoes of a person to whom 50 years of charity work is important, which would be different from, say, an airline pilot who's never done charity work.
Right, but it's still the person's individual subjective feelings are irrelevant. We create the fiction of the reasonable person who is highly engaged in charity, and we determine whether it should be offensive to that reasonable person, not the, borrowing back from law school, the eggshell skull person.
I think where that goes off the rails is with illustration 9 to comment C of the restatement section that we're talking about, wherein the court or the restatement says that when that pilot in that illustration sees that there was a movie made wherein he's praying with passengers and reassuring them, whether that is offensive to him is a jury question. And whether that is offensive to him is the important part. The illustration doesn't say a reasonable pilot. It says that reasonable person is the one that has to be evaluated by the jury.
The reasonable person is objective.
I think we're really quibbling with semantics at that point.
And semantics matter in the law, so.
Absolutely. But in this case, when the interest to be protected is a person's feelings, whether the person's feelings were reasonably hurt under their circumstance is different from whether the feelings of another person not in that position.
So I think we can all agree that a person who could care less about charity would not be offended by saying you're not uncharitable.
Yes.
Okay. That's a easy statement to make. So the question that we have is, would a reasonable person who cares about charity, but it's still a reasonable person, are they going to be offended by this? And not only offended, is it highly offensive? So not, oh boy, I wish they hadn't said that, but this is the kind of highly offensive statement that is per se damaging to my emotional well-being.
Sure, sure, you can't argue that
So did the
someone's-
court, the question that you're arguing now is that the court somehow misapplied that standard in saying reasonable person, but reasonable person is the standard.
reasonable person in the plaintiff's position, and the trial court did not say
And we
that.
presume that the trial court knows the law, which, I mean, there's multiple cases that say it's a reasonable person in the plaintiff's position. We presume the trial court knows and understands the law. So what's your basis for saying the trial court didn't?
Because the trial court did not say that in their order.
Okay, even when they don't say it, we presume they know and apply the law. So they got the reasonable person right. What is your basis for saying they didn't say in the person's position? Or didn't apply that in the...
Because there was no evidence in the order, there was no discussion in the order that trial court considered the position of a person who was interested in charity, or to whom charity was very important. That's not what the trial court said. They didn't go down that road with that analysis. They stopped with objective, reasonable person standard.
I mean, actually, it seems harder for you to get past a motion to dismiss if it's a subjective standard, because then you actually have to plead what her subjective feelings were, whereas if it's a reasonable person standard, reasonable person is not something we usually decide on a motion to dismiss, right?
Well, generally not, but that would be a jury question. In this case, the complaint alleges that she was in fact, her feelings were in fact hurt by this, and she was offended by it. So that statement, accepted as true on a motion to dismiss, should be enough to get to the jury. Now, if the court had gone back, the trial court, and analyzed, well, let's take a person who's has been 50 years in charity and to whom this is very important, as she pled in her complaint, would this be offensive to her or highly offensive, and is it a major misrepresentation of her character? The trial court did not go through that analysis. I can't speak for what the trial court was thinking about, because all I have is what they said. And what they said was objective, reasonable person standard, without mention of in the plaintiff's position.
Judge Payton has asked me to ask, taking what you've said so far as accurate, how is this statement, now the statement is that charity is not what it seems, and there are strings attached, I don't remember the exact word for word, but how is this highly offensive to a reasonable person in the plaintiff's position?
If she, the plaintiff, thinks charity is very important to her, and the community of charity is very important to her, then for someone to say that her charity isn't real, I mean, we're talking about the actual virtue of charity. And if someone says it is false, it is...
Isn't any charity that's other than anonymous has some strings attached? People do it for reputational or other gains. So, I mean, isn't there multiple meanings that can be attributed to this statement?
If you take apart each word, yes, you could probably attribute multiple meanings to that. But in the context of this email, wherein Ms. Adelson alleges, I was taken in only to find out, she's not stating an opinion or some kind of a loose figurative thing. She's stating as a fact, I was taken in and the charity is false. And that doesn't even get into, and by the way, she was married to and countenance behavior of not just a criminal, but a repeat offender, which is objectively untrue.
I think.
Is it objectively untrue? I mean, in our record, we don't know, but...
Yet, at the time that the email was written, none of the Gaines couple had been convicted of anything.
But he was subsequently convicted.
Subsequently, he pled guilty
to crimes that had occurred. I mean, you can call someone a repeat offender criminal based upon what they've done, not necessarily the conviction.
but at the time that the email was written, that was not the fact. At the
No,
time
no.
that
It was a fact. He had committed those crimes. He just hadn't been convicted of them yet. So if someone robs a bank, they are a criminal. They are a convicted criminal when they're later convicted of that offense.
Well, I think Mr. Gaines would be...
It doesn't matter. It's not in our record, but I would not say that it wasn't true. You just say that he hadn't yet been convicted.
Right, and when he pled guilty, the thing that he pled guilty to was, and not that this is part of this case, but the thing he pled guilty to was the sale of an unregistered security. So to call him a repeat offender is in fact false.
He had previously entered into settlement agreements in civil matters.
Yes, which
Okay.
does not make him a criminal. And there's no evidence that Ms. Adelson knew about that when she wrote her email. When she wrote her email in her affidavit, she presents this idea that she was going to attach a news
Yeah, so we
article.
don't know actually if when she's talking about repeat offender, is it a repeat offender on his lack of charitable givings or the criminal behavior? I mean, you said to me earlier, these are capable of multiple meanings, so
Sure, but
it
I
could be
think
either one of those.
that stretches, I think, a bit when we're talking about an offender and a criminal, because that's what the email says. He's a lurking criminal and a repeat offender. So just looking at the four corners
Isn't
of
the
the email.
context of charity the entire statement?
I'm sorry?
Isn't the entire statement in the context of the charitable giving as well?
I think it's both.
Yeah. Multiple meanings, as you said.
I don't know that we can extend the context of the four corners of the email.
But I think you conceded in your opening brief that the multiple offender was a statement about Mr. Gaines.
Correct.
Okay, so it's not of and concerning her either way, so that's kind of not before us.
Well, I disagree with that, because the implication here, and implication is relevant to all of the claims that Ms. Gaines made, is that she is married to and countenance.
The married to, I understand your argument, but there is nothing in that statement that says she is a multiple offender. It is him that is a multiple offender.
I think it implies that she is also an offender.
Based
So-
on the prior sentence, so she says he's a criminal, and then she talks about the charity stuff, and then says he's a repeat offender. Is it your argument that somehow that statement is looping in your client by making it sound like what they're doing in that second sentence is also a crime?
Sure, if she is countenancing his behavior and has remained married to apparently a repeat offender,
Well, the second sentence says she's actually engaging in that activity with him.
as far as the charity goes, yes.
Right. And so if the repeat offender is referring to the activities that they're, undertaking in that second sentence, then the repeat offender statement could be read to be referring to your client's activities as well. Or have you not
But
made
no,
that
you just
argument?
told me a minute ago that that was a stretch to say that that might have been referring to charitable stuff.
Right.
Okay, so your statement here, position here is the repeat offender is solely regarding the criminal activity.
Yes.
And in your opening brief, you said that applies only to him. Now, you have a broad argument that, well, it implies that she's married to a criminal.
Yes,
So that's your argument, and we can move on.
that's correct.
Okay, thank you.
If you do get discovery in this case, how would you go about trying to prove that the statement about their charitable activities was objectively false? What types of discovery would you seek?
Well, I would seek to enumerate all of the different charitable activities that the Gaineses have been involved in. And when we talk about if a gift was rescinded or something, in this case, we have hearsay evidence of 2 instances over the course of 50 years and dozens of millions of dollars. So now we get into a discussion of substantially true. So I would have to cross-examine Ms. Adelson on what this information is about the substantial truth that she alleges, and I would have to present evidence of the entirety so that the fact finder could then determine, okay, if we have these 2 alleged instances, and let's assume for the sake of argument that they're true at this point, does that render her email substantially true?
I mean, how would you show that their prior charitable activities did not have strings attached?
I don't know that I would have to prove the negative in that instance. I think it would then be incumbent upon Ms. Adelson to prove the positive, that they did in fact have them, because her email necessarily
I thought the
impugns...
burden was on you to show that the statements were false.
I have to show that the statements are false, and she has to argue that her statements are substantially true. And I would argue that over the course of 50 years, if, again, assuming for the sake of argument, that there were 2 instances where a gift was rescinded, perhaps for very good reason, or perhaps she's got the context wrong, I would have to prove that her statements were substantially false.
You were talking about false light. Are we moved back to defamation yet, or because I don't want to steer you away from your?
I thought we were on defamation now.
Sure, we're still on defamation, but...
But you started with false light. We've moved to defamation now.
Well, that's correct. I started with false light, and I still had more on false light, but I think we understand the issues in the false light claim, especially based on illustration 9 to comment C of the restatement section.
Did you plead special damages, and are you required to?
At some point, I have to plead some damages, and that becomes difficult when you're talking about torts that are as soft as these.
But you did not plead special damages, and during, I think, argument or in one of your responses below, you said it would be difficult, if not impossible, to prove those.
Sure. In the case of, yes, I agree, it would be difficult to prove, but not unprovable. And general damages are perfectly reasonable under a false light tort, and they're also reasonable under...
Let me lay out a thought that I'm having.
Sure.
And this is why we're here, so you can disabuse me of what's wrong with this thought. There's two types of defamation. There's defamation, and then there's defamation per se. Defamation requires pleading special damages. You didn't do that, so we now move to defamation per se, which can be where damages are presumed. Let's assume that I'm right in that, for purpose of our argument. Is this defamation per se?
Yes.
How so?
Because defamation per se specifically enumerates the things that can be defamed, and those include an impugnment of Ms. Gaines' character, virtue, reputation. It's not just a commercial tort as claimed by the trial court.
Right. What types of statements in here impugn her character?
That her charity is false, that her gifts, and that she is deceitful, and that she's married to a criminal. So
being married to a criminal is impugning my character? If my wife had a felony conviction, that means there's something wrong with me?
If the claim is she's married to a criminal who is a repeat offender, then yes, I think that, especially when it's untrue. If it were true, that's different. He was not convicted of anything at the time.
We can debate that, but
Is dishonesty one of the categories where you can get defamation per se?
I believe that it is. Hold on. Yes. According to the Olitsky case, libel per se in Arizona are those communications which on their face falsely tend to impeach one's honesty, integrity, or reputation.
do you agree or disagree that defamation per se statements cannot be capable of more than one meaning? That they have to be so clear-cut as to say that there's the only interpretation you can apply to these is that they are attacking your character?
I think it becomes a reasonableness interpretation at that point. I mean, the question comes back to what would the reasonable person assume when they hear that statement. It's not what the person who made the statement meant. And when you hear, I was taken in only to find out all her gifts have strings attached, not just some. She just said her gifts have strings attached. Those are statements of fact that would lead a reasonable person to believe that Ms. Gaines' charity is false.
In Boswell v. Phoenix newspapers, we said libel per se in Arizona are those communications which on their face falsely tend to impeach one's honesty, integrity, or reputation. So that would be your argument, is that on its face those statements do one or at least one of those things.
Yes, that's correct.
Okay. Then we further said whether communication is libelous only by considering extrinsic information, then it is considered libel per quad and actionable only upon proof of pecuniary loss.
Right. And in this case, the email, it's very short, so it's easy to parse, specifically impugns the virtue of charity, specifically impugns...
Do defamatory statements need to be capable of being disprovable in order to be defamatory?
I think they do. I think they must be capable of being proven substantially true or not. And I don't think you're going to find an instance where it's always 100% true. For instance, if my spouse were to ask me, is this outfit flattering on me? And it objectively is not. And I intentionally lied and said, oh, it looks great. Does that then mean that I am a dishonest person and people can then defame me by claiming Mr. Grimm is a liar, he makes up stories and is intentionally false?
So are statements like this then that, charity is not what it seems, comes with strings attached, etc., are those capable of being disproven then?
Well, I think so. I think that when you have somebody who has devoted the amount of time...
I mean, strings attached is kind of an ambiguous phrase. It's certainly capable of multiple meanings in this circumstance, isn't it?
Oh, I would disagree. I think that either does or does not have
Is
strings
any
attached.
charity other than anonymous charity free of any attached strings?
Sure. They don't. The charity is the gift. The charity is the act of giving the gift. And over the past 50 years, if you've got a litany of gifts that were given, to say that they all have strings attached, which is what the email says. It doesn't say one or two. It says has strings attached. That says that the charity is only there to gratify Ms. Gaines. And unless there is some proof that says that's how she gives her gifts, well, then the statement is false.
Do you want to save some time for rebuttal?
I have 43 seconds that I should probably save for rebuttal.
Good morning. May it please the court. I was taken in by his and his wife Cheryl's apparent philanthropy only to learn that it has strings attached and is only a pledge that may never happen. Can this court determine that the statement is false? No. Is this offensive, highly offensive to a reasonable person? No. Is this legal action seeking $1 million in damages plus punitive damages justified by the law of defamation and false light invasion of privacy? Absolutely not. Barbara Adelson was stating her subjective beliefs and impression, which lacks objective criteria that this court can measure. Barbara was clearly exercising her constitutional rights of lawful free speech as the trial court correctly determined in this case.
Is this a matter of public importance?
It doesn't have to be.
This is a private dispute between private people.
Correct, Your Honor.
So you're not claiming any type of heightened First Amendment protections that apply like New York Times v. Sullivan in this case?
No, we're only claiming that this is freedom of speech and that the anti-SLAPP statute applies, which does provide for a mechanism for cases like this to be disposed of without discovery and the unnecessary chilling of free speech.
But if Ms. Hintzen Gaines is not a public official, she's not a public figure, and this is a matter of private concern, then I don't think the First Amendment has any bearing on it whatsoever based on the case law. I mean, if you look at the Mraz case from the Supreme Court a couple of years ago, it says when it's private concern with private people, we don't do First Amendment at all, including Yetman and Milkovich. So I just wanted to get your response to that.
Well, the Arizona Constitution states that all citizens have the right to free speech, only subject to certain abuses.
I don't have your brief in front of me. Did you cite to or rely on the Arizona Constitution in your briefing?
We did, Your Honor.
You did?
I believe so, Your Honor.
Okay, I just didn't, I'm not arguing with you, I just didn't hear whether you said we did not or we did.
Oh, we did. I can find the index of record if you'd like, Your Honor.
No, I believe you.
Okay. And so, yes, in the very beginning, we actually the case, Rogers, that Your Honor just mentioned, freedom of speech is the foremost within the pantheon of constitutional liberties. And then we went on to cite the anti-SLAPP statute, and I believe later on the Arizona Constitution as
Now
well.
you're saying I believe later on. Tell me if you cited the Arizona Constitution's free speech protection provision. I don't remember it off the top of my head. I'm embarrassed to admit. And are you arguing now that there's some difference between the Arizona Constitution's protection and that of the First Amendment that Mraz didn't seem to notice?
So, Your Honor, on page 10, section 2 of our legal argument is where you'll see that we quote and discuss both the Arizona Constitution, Article 2, Section 6, which provides, which the sign here court described as the right to free speech is granted directly to every Arizona and is not merely a protection against government action, as is the First Amendment of the United States Constitution. And
So can a statement be defamatory if it's not capable of being proven false?
No, it must be capable of being proven false, and that's
And I think your opponent agreed with that statement as well.
yes, and that's why all these claims fail. Is that this is Mrs. Adelson's opinion, an expression of opinion and subjective beliefs that cannot be,
Sorry to interrupt, if an opinion implies facts, that can be defamatory, right?
if an opinion implies facts that are false, it can be defamatory. And if they are presented in a highly offensive way, they can be false light, invasion of privacy, neither of which we have here.
Like Roger says, in an ordinary defamation action between private individuals, a speaker may be liable for damages if a falsehood is published that injures the plaintiff's reputation. And that's what we have here. I think we have an ordinary defamation action between private individuals about a matter of private concern.
That's paragraph 12, if you're
Right.
keeping track from Rogers.
And then the case says, quote, unless this is free from reasonable doubt, it is for the jury to determine the meaning and construction of the alleged defamatory language. So how would you apply that statement of the law to these facts?
The threshold issue needs to be decided as a matter of law by the court, and that threshold issue is
I
whether...
think I only think that's true if Yetman and Milkovich apply. I don't think that's true if we're not in that First Amendment protected territory, and I don't think we are here.
Well, Yetman, which cites Milkovich, also says it does describe that it's potentially a clear, I think it used the word, a clear consideration, but it also recognized that there's going to be circumstances where it's just not provable as false. So it looks at both situations.
But those are in public, dealing with a statement about a public figure in Yetman. So does that protection apply for a private figure in a private matter?
We submit it does, Your Honor.
Based upon what authority?
Unfortunately, most of the authority is regarding public matters and public concern in the state of Arizona. But what's really important here, we believe, is that the anti-SLAPP statute, which was just amended by the legislature in 2022, 12751, takes out the element of public concern and allows private matters to be determined under the statute and look to see if it's constitutional protection that is being chilled and retaliated against by the action. And so I think the legislature specifically recognized that this was an issue that needed to be dealt with private citizens, because there was too many defamation cases that were subjecting the courts to abuse. And so they put in specific mechanisms for private individuals to be able to move to dismiss a case, not just on the 12b6 standard, which has to assume the facts are true, but rather put in a mechanism where there is a burden-shifting standard, as here, and the parties have to come forth with evidence to show that their claim has merit.
Right, but 12751A, which is the anti-SLAPP statute, says in any legal action that involves a person's lawful exercise of the right of petition, the right of speech, the freedom of the press, the right to freely associate. So to me, that then begs the question, which is, are we dealing with the right of speech here? And if both the Arizona Supreme Court and the U.S. Supreme Court has said the First Amendment doesn't extend to statements involving private figures and private concern, then I'm not sure that the First Amendment or the anti-SLAPP statute kick in.
The private figure and the private concern goes to, for example, I believe it's the Dombley versus Phoenix newspaper case, was actually dealing with a private individual and a private concern, and that was looking at the defamation per se. So, of course, defamation only is applicable if you don't have the freedom of speech and you're abusing that right. So while I do think there is not a lot of case law dealing with these circumstances of private individuals and private rights, the First Amendment, and more so the Arizona Constitution here, which is really the issue, does protect Arizona's freedom of speech and only allows these kinds of causes of action.
The free speech clause in the Arizona Constitution says you can speak freely, but you're subject to the consequences of doing so. And to me, that's always been a textual clue that the founders were recognizing defamation claims and the defamation that existed at the time the Arizona Constitution was enacted.
I do believe, Your Honor, that there is a right to bring a defamation case if you can state the elements of defamation claim.
Right, but I guess I'm just pushing back a little bit on the idea that maybe the Arizona Constitution extends protections further than the U.S. Constitution, based on that second qualifying clause in the free exercise provision of the Arizona Constitution?
Well, I think both contemplate limitations on freedom of speech. And it's just looking at the specific circumstances and the specific causes of action to determine whether it's actionable. And that's why we have these mechanisms early on under 12b6 in the anti-SLAPP statute to look to see, does this have merit? Does this have evidence? Is this something that's just opinion or substantial truth? Or does it fall into these limited categories where it's an abuse of the freedom of speech? And therefore, a defamation or false light invasion of privacy claim can move forward through the judicial system. But we have
Going back to Rogers, when it says, unless this is free from reasonable doubt, it is for the jury to determine the meaning and construction of the alleged defamatory language. How can I make that determination here on a motion to dismiss? Particularly if Yetman and Milkovich don't really apply and we're not serving a gatekeeping function, then at that point, we're just in normal Rule 8, Rule 12b6 land where I have to accept all the allegations are true and look at the complaint in the light most favorable to the plaintiff.
Well, Your Honor, I would submit that under just a 12b6 standard, looking at the language itself, the court can still say that there is no likelihood of prevailing on this claim under believing the words as true as the complaint is stated. The email is what the email is.
Wait, what's your authority for saying that the standard is there's no likelihood of prevailing? Is we can grant or affirm a motion to dismiss on that?
Oh, I apologize, Your Honor. I was thinking about the justified under law under 12751 when this court in particular is looking at de novo review of a 12b6. We look at dismissal appropriate only if, as a matter of law, plaintiff would not be entitled to relief under any interpretation of the facts susceptible of proof.
Right. So it's not the likelihood of prevailing that's the standard. It's
correct, Your Honor.
Okay.
I apologize.
okay. I believe me, I make plenty of misstatements up here, and luckily you guys are here to correct me.
Justified by existing law is the one that's really caused a little bit of confusion in my brain, I think, because it is not, there's nothing in the anti-SLAPP statute that explains that provision. There's nothing that we've found in the case law that describes what that standard is. And so that's really what we've had a tough time in looking at the other anti-SLAPP statutes around the country and determining what the shifting of the burden is looking at in this case.
Turning to false light, I noticed when I was doing some research that a lot of other states have rejected this claim altogether, but Arizona has recognized it. But we've put that God be here standard of it has to be highly offensive. Mm-hmm. What is your best argument for saying these types of statements, even though they're offensive, may be offensive to a reasonable person in her position, don't cross that highly offensive threshold as a matter of law? So what is your best argument or best authority for that proposition? And respond to his comments regarding, I think it's comment 9 in the restatement. Or
yes,
example
yeah.
9. Which is it? Whatever.
Illustration.
Illustration. Thank you.
Yes, Your Honor. So the God be here case is looking at infliction of emotional distress, and then decided that the false light invasion of privacy claim may exist under certain limited circumstances, and the case went on to state specifically that it was a reasonable person standard. So we respectfully disagree with the appellant's position that we look to the subjective standard. I think Your Honors have probably heard enough on that already, but what we contend is that it's a reasonable person standard, and the restatement 652 actually says this in the restatement. It's only in the illustration, which is not the restatement of law, where one specific illustration, 9, looks to or says the word regarding the subjective person. And in that situation, they were looking at, as counsel mentioned, whether the pilot was praying and reassuring passengers. And I would submit that the pilot's position is describing whether a reasonable person would be offended, not whether him himself would be offended by this description. So would a reasonable person be offended by this presentation of him praying and him reassuring passengers? So in this circumstance, In this case, the question asked would be whether the trier of fact finds Barbara's opinion that she was taken in by Ms. Gaines' apparent philanthropy only to learn that there are strings attached and pledges that may never happen.
Yeah, and I'll tell you, the thing I struggle with is I was reading illustration 9, and in my head I was thinking, none of that it doesn't sound that bad. And then it says, well, whether that was offensive is a question for the jury. So it sort of makes me doubt my ability, particularly on a motion to dismiss, to determine what would be highly offensive to a reasonable person in these circumstances, when right now I just have a cold record with a motion to dismiss. I have a complaint, and then I have the briefing on the motion to dismiss. So, and I don't have any discovery on what, the plaintiff's individual circumstances are. So how do I, as a judge, sitting with a cold record, how do I determine on a motion to dismiss whether something like the statement that was made is highly offensive or not?
Well, you ignore the subjective
Right.
sensitivities of the plaintiff. The case law is clear on that. And it has to be something that is so outrageous that it sparks an outrageous reaction. And this is not something that sparks that.
Right, but I didn't have that reaction to illustration 9, and it says that plaintiff was entitled to a jury trial on that issue. So are there other cases that I can sort of use as guideposts to determine what falls into the highly offensive bucket and what doesn't?
There is not very much case law on that issue in particular, but what I would submit is that if you look at certain other examples of situations where it's first of all, you have to get past the fact that it's not false. And here I would submit that
Well, it doesn't have to be, right, for false light?
it can be a false impression that is highly offensive, correct. And I think that's mainly what we're dealing with in this circumstance, and the highly offensive standard. But whether someone would find this circumstance even a private matter, I believe is questionable. I think that's something that could be looked at on a 12b6, is that this really isn't a matter of privacy. This is public issues. This is public donations and charity, and to the extent there was any discussion there was with counsel regarding the criminality of it, obviously that's a public matter that is free for the public to know about, and in this circumstance very much was. But the question of whether a reasonable person would be highly offended by the statement alone is putting aside the sensitivities and may be relevant to a damages situation, but not whether the statement is actually actionable as highly offensive. I think the situation when you're talking about a tragic incident where someone is praying and there's a religious connotation, that may be something that's highly offensive. A lot of the discussion in the case law and in other cases that are in this kind of realm is about politics, religion, things that people care deeply about and are very convicted on. And so those are circumstances where people would likely find certain presentation of the facts highly offensive.
Well, I think the plaintiff would say I'm highly convicted about donating to charities, and that's now my life. It's something I do all the time, and it means it has deep meaning to me. So how at this stage can I say what her circumstances are, let alone that it's not highly offensive?
I think by looking at the language itself. And looking at the language itself, it's not stating an objectional fact. It's stating an opinion. I was taken in, and she believed her impression. It's not stating something objective. It's not stating, for example, it's not stating something like Jane Doe killed Joe Doe because she was having an affair, or something that is actually you can decide part of it is true or false by objectional facts.
If she says it's highly offensive to me, I need to accept that statement as true, don't I?
I don't believe she ever did state,
But
in
even if she
fairness,
did,
in the
doesn't
complaint.
Godby here say, quote, the plaintiff's subjective threshold of sensibility is not the measure? So I understand your opponent's comment that we have to look at the person in that position, but our Supreme Court has told us that to the extent there is a subjective element to this, it is extremely subservient to the reasonable person standard.
Correct, Your Honor. It's very clear. Subjective sensitivities are irrelevant to the determination. So it's an objective standard that may look to whether a reasonable person would find the presentation highly offensive. Not
In her circumstances, right?
Yeah.
I guess, how do I know what her circumstances are on a motion to dismiss?
Well, I believe that it doesn't look like her circumstances. We contend that it is just an objective, reasonable standard. There are other cases that state that standard, such as God Be Here. And I believe that the Arizona Supreme Court should trump an illustration in 652E, which 652E in the restatement itself says a reasonable person standard. It is only in the illustration that there is one comment about it being from the subjective standard at best.
Yeah, the restatement says, and it's in comment C, it's only when there's such a major misrepresentation of his character, history, activities, or beliefs that serious offense may reasonably be expected to be taken by a reasonable person in his position. And I think in God Be Here, the court adopted 652E, so. So are you saying that we don't look at it to this person? God Be Here sort of says we don't look to that part of the restatement?
I believe that the restatement itself says that it's just a reasonable person standard, and if you're going to look at the subjective standard, you're looking at the presentation being highly offensive, not her sensitivities, not standing in her shoes as I'm offended or not. I'm a person who's rarely offended, and so I'm not the reasonable person. I'm not the objective reasonable person. I don't, and so I think my time is up. So thank you, Your Honors.
Mr. Grimm?
Thanks, Judge. The main point that I would raise from my short time on rebuttal is, as it's expressed in the God Be Here case, in paragraphs 2 and paragraphs 5, where they sum it up in paragraph 5, the tort action for false light invasion of privacy provides protection against a narrow class of wrongful conduct that falls short of outrage, but nevertheless should be deterred. And
the court also said plaintiff's subjective threshold of sensibility is not the measure, and trivial indignities are not actionable.
correct. And for a person who is a reasonable person who is involved in charity, I would submit that to claim that the charity is false, I was taken in only to find out the fact that the charity has strings attached and all the things that are in this short email would be highly offensive to a reasonable person who is involved in charity in the way that Ms. Gaines is.
Okay, thank you.
Thanks, Judge.
Thank you for your argument and your briefing. We'll take the matter under advisement and issue a ruling in due course. We stand adjourned.